Good evening, colleagues. Trust you well. Um, I hope you can hear me. Trust you well. Yep. Yeah, yeah. We're gonna talk about it tonight. Yeah, the distortion within the traditional and Khoi-San Leadership Act. So that's what we're gonna be talking about tonight. Um, it's just uh, it's just unthinkable that we have come to a place, where we've been taken on a ride, where I don't know if people fully understand what we're dealing with here. There's clearly misdirection. Our people are being misguided, absolutely misguided. So yeah, okay. Let's before we get in there, we can hear you loud and clear. Thank you very much, Leader Peter. It's good to have you online, and thank you, Danny. And the rest of the other colleagues, I see there's some other colleagues also online. But thank you. It's a very important discussion tonight. Thank you, um, uh, Chamonix, Red Boy, um, Martinez Base. Thank you. Good evening, colleagues. It's good to have you guys on board tonight. This conversation could not be more critical, more important, and the timing is still absolutely relevant, very relevant. We're gonna be talking about the distortions. I mean, there's a number of people who's been giving all manner of information with regards to the Traditional and Khoi-San Leadership Act, and then people are still in limbo, and people are still asking whether it is an act or whether it is a bill, you know. And we can look at that again a little bit, very briefly. But I really want to put the emphasis tonight on the distortions. You know that people have been distorting what the Traditional and Khoi-San Leadership Act really is doing or supposed to do when they say that it is there to recognize us. Colleagues, it could not be further from the truth. There's just absolutely no way that we can be sitting around here and we can be calm and happy and think that this Traditional and Khoi-San Leadership Act, Act number 3 of 2019, is the panacea, is the savior of the Indigenous San and Khoi community. It's good to have the Honorable Peter Tony Satchel, also an astute legal mind, together with the Judge Elmery. You know, those are two old school attorneys, brilliant minds at that, both Elmery Tyson and Peter Tony Satchel. They are some of the old school, and so we're glad to have those two brilliant legal minds also on the platform. But we're going to get into it in a short while, colleagues. We have to deal with this decisively. We cannot allow our people to be left in the middle of nowhere, and then people are being told that there is no other way out. That's what we heard on Monday night, that the only way for us as the Indigenous Khoi and San people, the only way for us to go is for us to accept the Traditional and Khoi-San Leadership Act. And we want to place on record here tonight that it's absolutely far from the truth. The Traditional and Khoi-San Leadership Act is by no means worth the paper that it is written on. And so what we'll do is We'll give you some comparisons tonight. We'll show you actuals. We're not going to speak in the sky. We're going to give you real, tangible things. We're going to make comparison. In fact, what I'm going to do tonight, I'm going to look at four particular things tonight in our discussions. So the first thing that we want to do tonight in the discussion, we want to bring clarity on the unfortunate comments by our Honorable Saintus van Wyk in his live on Monday night. So what we must not do, we must not misconstrue the fact that we say we are bringing clarity to the unfortunate comments of Honorable Saintus van Wyk, and then people misconstrue that and say, no, we are fighting with Leader van Wyk. We are not. We are not going to use this platform to take or to slander any of our leaders. We've got great respect for Honorable Saintus van Wyk, who's an MP with one of the political parties. So we've got respect for him, but we have to clear up the absolute misguided interpretation of what the TKLA really represents. So that's one of the first things that we want to do. But again, colleagues, we want to be emphatic. We are not here to fight against our own. We're not going to do that. We're saying that what we just want to do, we want to clear up, we want to clarify some of the very unfortunate comments that came through his live on Monday. And hopefully we can help him. And many of them who are sitting in there within Parliament, some of the MPs that are sitting in them, hopefully the clarity that we provide can assist them so that they can dive deeper, so that when they come onto a public platform, so that they're better informed, and also we would love to encourage them to knock on the door of people like us who've been, we've been here for more than 25 years. We're working in the space. Why would you not knock on the door of people who've been working long and hard at this? We're not doing this on a weekend or when we have some time. People in IFNASA, including myself, we do this on a daily basis. This is our life. We live here. So we don't do it just by the way, So, yeah, okay. Hopefully the audio is okay. Just indicate if the audio is okay, colleagues, so that we can just anybody there just before we get into the second part of what right. How's the audio, just for those who are listening, so that we can get because I think somebody said the audio might be a little bit of problematic. Right, but you let me know. But Denny, audio, can you guys hear Elmarie? The other learned friends, can you hear us well? Right. Okay. Let's continue, and you'll let me know if the audio is not too nice. We said tonight the first thing that we want to discuss, we want to clear up the unfortunate comments of Honorable Saintus van Wyk, who's an MP in Parliament in South Africa. Secondly, we want to talk about the TKLA, just high level, just report to you, and so for many people who don't understand that the TKLA has already been declared unconstitutional and invalid by the Constitutional Court already in 2023. So we'll just quickly touch on that briefly. And then number three, what we'll do is we'll do a brief comparison between UNDRIP and the TKLA. Now, UNDRIP is, for those who might not know, the United Nations Declaration on the Rights of Indigenous People versus the Traditional and Khoi-San Leadership Act. We want to do that because we want to show you, what government wants to give us, all right, in terms of the TKLA, and what government has committed to in terms of UNDRIP. So we'll go in that. So those are the three major things that we'll look at tonight. And then lastly is a call to action for us to share, get involved, get in touch, share, email, support, whatever the case may be. but mainly, chiefly, the first is to clarify the misconception and the distortion in the comments of a very important leader in our community, Honorable Saintus van Wyk. Secondly, is to talk about the fact that the TKLA has already been declared unconstitutional and invalid, and what that means. And then thirdly, we will make a comparison between UNREP and the TKLA. So those are the three things that we really want to share some light on tonight. So let me get into it. I know, I mean, we're not a lot of people yet, but the rest of the people can get the video, and then we can have a discussion even offline. So let's take for argument's sake, let's get into tonight's discussion. I'm of the view that when you enter the public space with information, I think especially when we are at when we operate at the highest levels that some of us are operating, you know. Sure. Okay. Let me just, before I get in and says organizer, there's just some people who's just been calling for help. Just a second. Let's just try and see if we can get some help before we get into the discussion. Right. But okay, the team is at the back. Danny, MJ, and you guys just shout and scream if there's anything that you think that we need to do. Say, only share even okay. So some people say that the organizer may have only shared the live with a small group of people, even on his page. I can see anything. I can't see anything happening. Okay, let me just quickly go and let me get the live the copy again, and let me go and share it on my page. Hopefully, some of the colleagues can get it there from now there. Okay, some people are complaining that they can't get through to it. So before we go on, colleagues, just give us a moment so that we can just get more people on board. Okay, so we have shared it. We have shared it now on my Facebook page. Right. Okay. There's some people. Okay, audio's fine. Thank you very much. Right. So I was saying that I think what's important, when all of us come in, including myself, including the colleagues at IFNASA and all the other organizations and institutions, whenever we come onto a public platform, it is important that it is imperative that we remain factual. You know, that we must make sure that we understand, we understand our subject. It's important that you at least give yourself the opportunity to really dive deep in. And some of the things that when I speak, some of the things that we do, we might not have full information at the time. And so what you would do is, just to protect yourself, you say, rather tell colleagues that you will go back and you will verify the information and so on, just to cover yourself and so on. So we submit that some of the stuff that came through Honorable Saintus live on Monday, when he was speaking about the TKLA, its implementation, its operations, the process, and how it's going to unfold. And when we must, first of all, just say we appreciate the fact that he is taking time, to come out and to share information with the community. It's important. We must also recognize that for many years, people didn't come out. Many people in Parliament did not come out. Simply just just don't care. They don't come out, they don't share with the community. And so people like the leader centers and them are doing good work because they're coming and they're sharing with our community some of the intricate work they're doing and then things behind the scenes. And then when you criticize, we must also be fair. You know that here is someone who's doing the community, in particular our community, a world of good and good favor. And so we recognize that, we recognize that as something very, very, very important. Um, but even with that, it's important that still important that we do as best as we can, that we make sure that when we provide the community with information, that the information is solid, it comes through, it is proper, it can be tested. But I know beyond this meeting tonight, I'm going to actually invite him for us to have a public discussion, a public discourse on the issue of the TKLA. It's important. It's important that we take people like Leader Saintus and Leader Ashley Sauls, Leader Glenn Tybosh, Leader Wesley Douglas, in particular those, and then some of the others that comes from our community who are in Parliament, that we take them alongside of us, that we educate them, that we help them. Remember, we've been in this space for many years, colleagues, and so we have learned a serious deal. We're not saying that we know. We're the only ones who know. Somebody was asking me the other day, "Oh, so are you the only one who is right?" It can't be, and we can't behave like we are the only people that are right. So, but that's something that we desperately need to address. As a matter of urgency, we need to address it, colleagues. Right. So thank you very much. That this is just remember, this is live. Just one second. Just so I'm live here, please, colleagues. The people at home is now just making just want to greet and to talk, and they're not knowing that we're live here tonight. So here we go. Right. So one of the things that came through from our brother Saintus was the and we agreed that we're going to do tonight. We're going to put a little bit of a balance in terms of the language. So ek wil 'n bietjie Afrikaans ook vanaand ingooi. Is baie belangrik, dink ek, dat ons ook Afrikaans ingooi, dat ons ook 'n bietjie van die Afrikaans bewus is. So een van die belangrike dingetjies wat Leer Saintus genoem het. Hy het genoem dat die Bantu en Nguni mense het ook gegaan na 'n kommissie toe om hulle self te gaan present en ook hulle saak te gaan stel, dat wie hulle is, dat hulle ook dat hulle chiefs is en so meer en so meer. En hulle het gegaan na die Nhlapo kommissie toe. So die Nhlapo kommissie is inderdaad was daar gewees, en die Nhlapo kommissie se werk was uit en uit om seker te maak dat alle dispute onder die chiefs en die leierskap van die Bantu Nguni mense, dat dit aangespreek word en dat dit aandag kry. En so die Nhlapo kommissie was belangrik in daai opsig in. Wat ons mis, almal mis, en wat selfs Leer Saintus het gemis het, is dat ek probeer nou vir die laaste paar weke kyk en soek vir enige bewyse dat die Bantu Nguni mense ook die tipe aansoekvorms wat hulle vir ons gee om aansoek te doen, dat die Bantu Ngunis ook so tipe vorms gekry het. Ek sê nie, daar was nie. Ek het probeer kyk en ek het probeer vra, ek kon dit nêrens kry nie. Ek weet dat daar baie van die Bantu Ngunis het gegaan om hulle saak te gaan stel. veral daar waar daar dispute was en so aan, het die kommissie spesifiek daarna gaan kyk om seker te maak dat hulle die dispute oplos. Maar dit is ook belangrik om te weet dat selfs die Intapo-kommissie het ook baie foute gemaak. Sowel so dat die Center for Law by UCT ook baie keer moes ingespring het en baie van die dispute opgelos het, omdat daar soveel foute gemaak was deur die Intapo-kommissie. Nie net die Intapo-kommissie foute gemaak, maar die Intapo-kommissie se metode, wat hulle roep in Engels en sê die methodology, wat die metode wat hulle gebruik het, was ook vanaf die apartheid-systeem. En so daar was baie dispute in terme van dit gewees. So die Intapo-kommissie, tot vandag toe, weet ons dat daar baie van die Bantu en Nguni 'n groot fights opsit, omdat hulle nie erkenning gekry het nie. So daar was 'n proses ook van erkenning. Die feit is net wat ons op soek is na. Ons op soek nou na nie dat die ouens dat ons dispuut dat die mense wel gegaan het vir erkenning nie. Wat ons op soek is na, wat se tipe materiaal, wat was die aansoekvorms wat hulle gebruik het toe hulle die erkenning aan die Bantu en die Nguni mense toegeken het. Ons het nie dit nie. So 'n mens kan jy kan alleenlik 'n appel met 'n appel vergelyk wanneer jy weet wat het hy ons gedoen. So leer Sente sê, nee, ons moet net onsself gaan present by die kommissie op Khoi and San sake, en dan moet ons daar self gaan uitsorteer, en dan moet ons gaan sê, ja, ons is koning, ons is chiefs, of ons nie chiefs nie, en so aan. Maar wat hy nie verstaan nie, is dat hy nie verstaan nie, ja, is soveel goed, absoluut soveel goed, wat nie ter sprake is nie, wat heeltemal verlore gegaan het. Ons moet eers verstaan, was daar dieselfde tipe vorms gewees wat ons mense nou onderworpe aan is, ondergewerp is. Dit wat ons moet invul, het hulle dit ook ingevul. Ons weet dit nie. Ons soek hierdie tipe bewyse, sodat ons weet met wat is ons gekonfronteer. Nommer 1. Nommer 2, wat leer Sentes ook miskien nie in ag neem nie. En hierdie sessie is definitief net om te help. Dis om te help dat ons die vacuum of die verskillende goed wat missing is, dat ons daai goede kan aanspreek. Dis al wat hierdie sessie is. Hierdie sessie is 'n sessie om te help. Nou wat is missing in die hele gesprek? Wat missing is in die gesprek, en wat Leer Sentes nou sê, as hy sê, wat ons moet doen is, ons moet nou net eenvoudig onsself onderwerp aan hierdie proses, sonder dat ons hierdie proses moet bevraagteken. Ons kan nie, leiers, dit is nie 'n manier dat ons kan, dat ons hierdie proses moet bevraagteken nie. Nou kom ons sê, nou hy sê in sy live wat hy gesê, nee, wat ons nou gaan doen is, ons moet net aanvaar dat die TKLA die proses is, en dan wanneer hulle nou in die volgende jaar of so, wanneer die kokta nou rondgaan in die lande, en dat kokta in die lande nou gaan mense 'n geleentheid gaan gee om hierdie wetgewing reg te trek, en dan gaan ons nou dan gaan maak ons net eenvoudig die wetgewing reg. Dit kan nie wees, dit sal nog nooit gebeur nie. Nooit gebeur het dat dit die manier is hoe hierdie regering gaan werk nie. Ek weet nie waar Leer Sentes al ooit was hy al betrokke met hierdie konsultasies in die verlede nie. Ons kom nie baie van die konsultasies nie, en ons kan jou verseker dat 90% van die goed wat ons op die tafel sit, 90% van die goede word net deur die public hearings en goed, al die goed word net heeltemal een kant gesmyt, En hy goed is werk net eenvoudig nie. So daar is nie 'n manier, kollegas, dat ons nou hier kan sit en kalm wees en dat ons onsself gaan onderwerp aan 'n proses wat absoluut nie reg uitgedink is nie. Nou kom ons praat nog so een of twee goed van daar wat recent se live het gekom het. En dan kan ons bietjie vanaand bietjie ook beter dieper ingaan in wat ons voorberei het vir die gesprek vanaand. Een van die goed wat hy noem byvoorbeeld, hy sê as ons nou nie hierdie proses van die Traditional and Khoi-San Leadership Act, as ons nie hierdie proses gaan volg nie, dan sê hy, nou gaan ons ons hele mense in so proses 22 jaar terugsit. Dis wat hy gesê het in sy live. Nou mens kan nie so argumenteer nie, kollegas. You cannot argue that it says no because there are some of us who really because some people were saying to me, no, but the leaders are tired, some of the leaders are dying. Can you not see that the leaders are not going to get the recognition and they will not be able to benefit out of this and so on? And so I said to one of the leaders, the day when we entered into this struggle, we all knew there's a high possibility that none of us will see the promised land. That's the reality. That's the reality. We cannot be running here and not even crumbs. If it was crumbs that the government was presenting, and people were fighting for the crumbs and so on, I am submitting to you tonight that we do not even have crumbs to talk about. There's absolutely nothing that the government has submitted that is tangible, that is substantive, that is noteworthy, or is something for us to even to consider. And we will get into the merits of that in a short while. And so therefore we want to put it on record that we cannot argue that because you are going to challenge the TKLA and because you're going to challenge the TKLA, now you're going to put the people 22 years back. We have nothing, colleagues. We have nothing. And we'll tell you what nothing is. Right? If you are talking about you're going to give some of the chiefs and you're going to give some of the, or rather not chiefs, in fact, we're going to get there just now, because there are no chiefs. We've got amongst us, we've got numbers, scores and scores of chiefs and paramount chiefs and people who identify themselves as kings and royalty and so on. We are submitting to you that none of you, as per this act, none of you will have any recognition as a chief or a king or a prince or whatever the case may be. Now, none of these people, and what people don't understand, what is in the law, is that when you call yourself a chief and you have not been recognized as a chief, that they can take legal action against you. In fact, you can be incarcerated. That's how serious this thing is. And so therefore we cannot argue from a base that says, and from a premise that says, because a lot of our people are dying and they have not personally benefited out of this, and on that basis what we must simply do, we must step outside of our sanity. We must leave our sanity one side, and we must become insane. And what is the insanity? The insanity is for us to accept this traditional Khoi-San Leadership Act, and all we must do is we must just tweak it. We must just change it here and there, and then everything is hunky dory. It's not that simple. It's much deeper than that. And I'm saying again, and I'm challenging, especially those of our people who are sitting in Parliament. I'm challenging them to go and actually read the Traditional and Khoi-San Leadership Act. Spend some time. Spend a day. Spend 2 days. Spend a week. Spend 2 weeks. Spend a month. Just go back and go and sit and read the Traditional and Khoi-San Leadership Act, and you are going to be in shock if you read it. I'm not going to go back, but I'm going to progress, because there's some other things in the act that I want to highlight tonight that I want you to have a look at, and so on. But I'm just saying that there's no way that we can argue that we're going to put the people 22 years back. We have absolutely nothing, colleagues. Absolutely nothing, right? So one of the things that our brother said, he says, Kokta had het nou 2 jaar gekry om hierdie ding reg te maak en nou kan ons al wat ons in toe sê, okay, wat julle moet nou weet, dit beteken nie dat die grondwet hof hierdie wetgewing ongrondwetlik en ongeldig verklaar het nie, en omdat dit ongrondwetlik en ongeldig verklaar is, nou gaan die wetgewing nie weer aan nie. Die wetgewing gaan nog steeds aan, want hulle dit vir nog 2 jaar weer gesuspend, omdat die hele proses van konsultasie, soos deur die Grondwethof aanbeveel in 2023, dit het nog nie gebeur nie. Reg? En hy's reg in terme van die tegniese kant, dat hierdie wetgewing is nog steeds in werking. En daarom is dit en Elmarie Thys het my oor die vingers, oor die nakkels geslaan gister. Toe sê sy vir my, Tony, toe sê sy vir my, maar daar is nie 'n grey area in law nie. Jy weet, en sy sê vir my toe, want ek sê toe vir haar, dis 'n grey area, want ons praat van die TKLA is beide 'n wetgewing en is 'n bil. En sy sê nee, daar is nie so 'n ding nie. Daar's altyd wat die wet doen, wat die wetgeleerdes altyd doen, hulle sit altyd sekerheid in plek. En so wat die Grondwethof gedoen het, die Grondwethof het gesê hierdie wetgewing is ongrondwetlik. Reg, ons klim nou sommer vinnig in die tweede gedeelte van ons gesprek vanaand is die feit dat die wetgewing ongrondwetlik is en ongeldig verklaar was, reg? So toe sê sy vir my nee, maar daar is sekerheid, die Grondwethof het sekerheid gegee. En wat sê die Grondwethof? Die Grondwethof sê dit is ongrondwetlik, dit is ongeldig, maar die ongrondwetlikheid en die ongeldigheid word dan gesuspend, word dan tersyde gestel vir nog 2 jaar. Dit was vir 2 jaar tot hierdie jaar Mei, die einde van Mei hierdie jaar, en so daar's nou nog 2 jaar wat die departement wat Kokta gegee was om hierdie wetgewing reg te kry. So absoluut, ek dink soos Tony daar so tereg sê, ek dink ons stem saam met Elmarie dat daar sekuriteit. So dit is 'n wetgewing. So daar's mense wat argumente sê nee, dis 'n bil. Ek weet nie wat sê Tony daarvan nie, maar dit is belangrik dan dat ons kyk na dit. Dat ek sê dit is 'n wetgewing. Ons het nou 'n hele paar prokureurs wat ook saamstem dat dit is wetgewing. Want dit kan nie, as dit nie wetgewing is nie, dan beteken dit dat die Khoi en San mense kan nie na die kommissie toe gaan vir erkenning nie. Dan beteken dit dat die hele proses is ongeldig, dit bestaan nie, want daar's nie wetgewing nie. Maar omdat dit wet is en omdat dit wetgewing is ek oortuig dat ons ook hierdie wetgewing, en hier's waar ons moet saam gesels, daai gesprek het Tony met Elmarie en die ander legal minds, dat ons dit bymekaar kry in terme van okay, nou dit is 'n wet. Onthou nou in 2016 het ek 'n saak in die Grondwethof aanhange gemaak. En daai saak het gegaan juis oor die TKLB op die stadium. En toe sê die Grondwethof vir my, hulle kan nie nou na die saak kyk nie, omdat dit voor parlement was, nommer 1. En tweedens het hulle gesê, hulle kan ook nie sien dat ons geprejudice gaan wees nie, reg? So, dis nou 2016, toe IFNASA hof toe gaan, na die Grondwethof toe gaan, en ons wil nou, dit wat in die bil in was op die stadium, wil ons toe gaan challenge, en die Grondwethof sê, nee, dit werk nie so nie. Hoe dit werk is, dit moet eers deur parlement gaan, dit moet 'n wetgewing wees, en dan kan ons daarna kyk en so aan. So ons het nou hier het ons nou 'n anomaly. Hier het ons nou 'n situasie waar dit is 'n wetgewing, maar dit is ook voor parlement. So is iets wat ons moet na gaan kyk, En ons gaan al die wetgeleerdes bymekaar kry om saam te gesels oor wat is hierdie? Is die TKLA 'n wetgewing waarmee jy kan werk, of is dit 'n bil wat jy dan dit nie kan na die grondwet hof toe vat nie, en jy kan dit nie gaan challenge nie. So that's those are some of the things that we need to do. But now this is important. So some of the leaders are saying, no, let's go present ourselves. Let's go present ourselves to the commission, and then we go there, and all we need to do is we just need to prove who we are, and that we've been I've been a chief, or my father or my grandfather was a chief, etc. Now, when you argue like that, we've got a serious problem there, because you see, we cannot argue like that. You cannot argue like that. You can't just say because the Bantu and Nguni has presented themselves before an Ntapo commission, and so therefore based on that, then simply you also now must subject yourself to a process like that, right? What they lose and what is missing from the conversation is the following: that the Bantu and Nguni people did not lose their culture. The Bantu and Nguni people did not lose their heritage. The Bantu and Nguni people did not lose the areas where they lived, the land mass where they lived. To a large extent, they didn't lose that. They didn't lose that unity, that togetherness. They didn't lose that language. They never lost their language. In fact, they kept their language. They kept their culture. They kept their cultural practices. They kept their history, much of their leadership. The leadership was to a large extent was kept together and was kept intact, irrespective of whether there was some challenges, even who's the leader and who was the leader. The truth of the matter is that by the Bantu and Nguni people did not lose their leadership the practices, did not lose the culture, did not lose the language, did not lose the cultural practices, the spirituality. They did not lose that. We lost all of that. We lost culture, we lost heritage, we lost language, we lost our land, we lost our existence. And so you cannot start the conversation with a bill, with an act. You can't say no because the Bantu Nguni people subjected themselves to that process, and therefore you are just going to subject yourself to that process without understanding what we have lost in the equation. So it cannot be that we are going to treat everybody the same. But that's not even the issue. That's not even the issue. The fact that we've lost our language, we lost our culture, we lost our existence. That's not even the issue. What's really at stake here is this piece of legislation. And so now let's dive into this legislation a little bit deeper. Let's get in there into the core facts, the hard facts of what is written, not conjecture. Conjecture just means speculation. We're not talking conjecture. We're not talking about speculation. Let's talk about really what's in this piece of law. All right, that these guys have put into this what is called the TKLA. Right. So we now know that it was on the 30th of May 2023 that the Constitutional Court has declared the TKLA unconstitutional and invalid. But it's important that you note what the Constitutional Court actually said. This is very important, colleagues. Very important. In fact, I just want to commend the life of the leader, Peter, not Peter, Tony Setcho, one of the Peter Joshua. It made a very beautiful live around the Richtersveld. And we're spending quite a lot of our time also, Leader Peter, dissecting the Richtersveld court case, because it's first of all, I mean, it's a brilliant judgment that came out in our favor as Indigenous, in particular Khoi people from the Nama descent. But equally, when you look at that court case, I mean, it's very exciting. The extent of what the judges wrote. I mean, the judges literally invited us. If you go and really sit and spend the night in that with their judgment, how the constitutional court was inviting us to come to the constitutional court and come and take up our land, and the rights within minerals which they have given. They have given the Nama people of the Richtersveld. Very, very important conversation. We must keep those conversations alive. Thank you very much for that one. But what I wanted to bring your attention to, as far as the unconstitutionality and invalidity of the TKLA is concerned, this is what the Constitutional Court wrote when they said. When they said that the TKLA is unconstitutional, this is what they said. They said, and I quote, "Parliament overwhelmingly failed in facilitating public participation." Now, public participation is critical in lawmaking, absolutely critical. There's a number of sections within the Constitution that speaks to that. You go to section 59 1A of the Constitution. It talks in particular about public, but the obligation on Parliament, or at least the National Assembly, their obligation of public participation. So you find section 72 1A of the Constitution, and including section 1181 of the A of the Constitution. All of these are mandatory, which means it compels Parliament and the NCOP and the local and the provincial government. So it's national parliament, it's the NCOP, the National Council of Provinces, including provincial government. All of these have got a mandatory obligation to have public participation. They didn't do that. So when you say to us, we must just accept the TKLA, when the TKLA was not properly consulted on, and the judges were saying unanimously, it was unanimously. Dat beteken almal saam. Het besluit dat guys, het besluit almal saam het besluit dat dat parlement het hopeloos dinge se gefail om hierdie public participation te hou, reg? So is baie belangrik dat ons daai hou. So as jy vir ons sê ons moet net hierdie TKLA aanvaar en die hof sê dit is overwhelming, and it was unanimous judgment geweest. That was overwhelming that they failed to facilitate public participation. Wat sê jy vir ons? Jy sê vir ons, ons moet hierdie ding net so aanvaar, en dan wat ons moet doen is, ons moet net paar goedjies gaan regmaak en gaan tweak hierso en gaan tweak daarso. Absolute nonsense. We can never subject ourselves to something as unconscionable like that. It's just, there's just no way that you can think about it like that. But let's now that we know that it's unconstitutional, it's called invalid, it was a unanimous judgment. Let's go a little bit further. Let's do the comparison tonight. Let's do the real comparison, because this is where the rubber hits the road. This is the real issue. This is the elephant in the room. When people argue that what we must do, we must just go in there and we must just subject ourselves without scrutinizing, without interrogating, and without dissecting, without taking this piece of legislation apart, which is the worst of the worst. I mean, there cannot be a worse piece of legislation anywhere worse than the TKLA. All right? So let's get into some of the issues in the TKLA. If you go to the TKLA, right? I don't know if you've got it, but there's 148 pages, right? But if you've got it with you, let's go to part 3 of the TKLA, right? If you're there, just if you've got it, it would be nice if you actually just have a look at it and so on. Let's go to part 3 of the TKLA, and let's look at this whole issue of recognition. That the I think this I think part 3 um, is on. I'll just give you the page now. As je nie die bladsy het nie, ek sal nou vir jou die bladsy gee. Maar is baie belangrik dat ons hierdie goed nou, kom ons lees dit saam met mekaar. Kom ons spekuleer nie. Kom ons sê nie ons 'n duim het wat sê hierdie goede nie, reg? So part 3 of the traditional Khoi-San leadership act, when it establishes the councils, right, is saying the following, right? So even some of the other things that we are arguing, if government is saying that we want to recognize the Khoi and the San people, right? And then they are going to recognize, as they have done, they're going to recognize us, and they use this act, right? They use this act to recognize us. The question we have, what is the source? Where is the TKLA derived from? I think I asked this question the other day, but it is important that we keep on asking that question, right? If we argue, and then here the learned colleagues must assist. If we argue that the Traditional and Khoi-San Leadership Act derive its power from Chapter 12 of the Constitution. All right? Now, what is Chapter 12? Chapter 12 has basically got two sections. Chapter 12, 211 and 212. All right? And basically, what is the Chapter 12 of the South African Constitution? Chapter 12 of the South African Constitution is the traditional chapter. It is the chapter in which they give the traditional leaders, give them their legal standing. That's what Chapter 12 is all about, right? Now, let's say government argues that Chapter 12 of the Constitution is where the Khoi and the San people, the section within this TKLA, that is where it derives the power from Chapter 12, right? And then they're going to talk about, because you'll read the words customary and customary law, etc., in Chapter 12 of the Constitution. Now let's say that's what they have used, right, as the base or the source of the law. Remember, there's no law that can exist outside of the Constitution, right? When there's law and when there's lawmaking, the law must be consistent with the South African Constitution, right? We agree with that. We agree that that's how it is. We don't necessarily agree with everything within the Constitution, but we agree that's how lawmaking is made in South Africa. That's the process. We don't necessarily agree with the process itself, but that's the process within South African context. So the question is, if Chapter 12 is really about the traditional and the Khoi and San people, why is it that this act is called the Traditional and Khoi-San Leadership Act? Why is there traditional and Khoi-San in the name of the act? You might be saying, but that's absolutely, I mean, it's not, it's a non-starter. It's got no real bearing. I'm submitting to you that when we submitted the name change, because when they came to us, it was only traditional. when they started. There was some engagement, but it was so just like the court said, it was overwhelmingly, a failure. It was just that bad. But when they did come to us, we have put in the name Khoi and San in there. But we had our own reasons why we put the name Khoi and San in there, because we already knew back then there's no provision in the Constitution for the Khoi and the San. It's not there, right? And we can talk about that a lot, and we can spend a lot of time there. I'm submitting to you, there's no real, and obviously the legal minds are going to argue with me that there might be some provision in there, right? I'm saying there is not, but let's park that for another conversation. Let's get into the traditional side of the bill, of the act. Under the traditional side of the act, it says the following. Under section 5A, the premier concerned must, by notice in the relevant provincial gazette and in accordance with the act, this act, recognize a kingship or queenship council, principal traditional council, or traditional council for such kingship or queenship, principal traditional community or traditional community, and now this is important, just listen from here, and define its area of jurisdiction. Point number one, define its area of jurisdiction, area, right? Secondly, indicating the portions of land forming part of such area of jurisdiction. Two very important things in here that we must contend with tonight. Twee belangrike aspekte wat ons gekonfronteer mee word. Iemand sê vir ons moet net hierdie TKLA aanvaar en klaar kry, en dan moet ons net die paar goedjies gou gaan regmaak. Verstaan die mense wat ons nou hiermee te doen is. Die wetgewing sê, wanneer die premier byvoorbeeld, kom ons praat nou van, kom ons praat van, in hierdie geval van die premier, reg? Want hulle is nie deel van die Khoi and San kommissie nie, so dis die premier wat nou hierdie erkenning moet gee aan 'n koning en koningin en koninklike rade, koninklike families, tradisionele principal traditional councils en so meer. Dan sê die wet klaar, van die begin, hier begin sê die wet, as wanneer jy hierdie mense erkenning gee, moet jy die volgende doen. Jy moet die area van hulle jurisdiksie, jy moet hy area moet jy gaan uitken. Jy moet hom gaan uitmap, jy moet hom gaan afbaken. Dis die heel eerste ding wat jy moet doen. Jy moet hulle jurisdiksie moet jy gaan uitwys. You must go and define their jurisdiction, die area waaroor hulle koning of koningin is, of oor hulle tradisionele council is. Jy moet die area moet jy gaan uitken. Nommer 1. Dan nommer 2. Ja, die is diep, collega's. Dan sê indicating the portions of land forming part of such area of jurisdiction. Now, if you go through the rest of this, and you must clearly understand that when these guys, when they crafted this piece of legislation, these guys were absolutely meticulous, and they were absolutely clear that they knew if they did not put area, and if they did not put land or land mass in the law, they were going to have a nightmare on their hands, because there was no way that any of the traditional leaders or those the kings or the chief kings and so on were going to accept being a king or a queen without land, without jurisdiction, without a given area, without a well-mapped area. They knew that. They knew it. And so therefore they put it in the law. But it is only under the section that speaks of traditional leadership. That's all it is, right? So it goes further on to say, provided further that the area of jurisdiction of a traditional council must include the area of a traditional sub-council where applicable. Even for sub-councils, there's area jurisdiction. For a traditional sub-council, they even have an area over which they govern, or their jurisdiction at least goes. Right? Even go a little bit further. The area of jurisdiction contemplated in paragraph A must be mapped, and such map must be published under the notice referred to in paragraph A. These guys were clear, guys. These guys were clear that they are not just looking at, you becoming some leader over people. These guys are clear. They worked out the land. They worked out a given geographical space. They say, you're going to be king, you're going to be chief, you have a traditional council. This is your boundaries. They worked it out, and then that map must be published. Right? Our people is coming to us and coming to tell us, no, we must just accept this thing, and we're going to go on and we're going to sit somewhere in a public consultation. And over there, we are going to just quickly tell them that, and then we're going to get it right. And then this government, this rogue government, this government is just going to go and give up and says, no, it's fine. We're going to change it, just like that. After they worked meticulously, they worked on this law to give their people jurisdiction over land mass, over area where they're going to govern over. And they gave us absolutely nothing. And someone wants to come and tell me that we are going to get that conversation right in a public consultation. Have you lost your mind? There's absolutely no way that we can do that. Colleagues, we've got a fight on our hands, and we've got to get ourselves ready. And one of the avenues that we at IFNASA is exploring, one of the avenues is obviously the courts. We're going to the Constitutional Court. We have no choice. You cannot tell us that this is fair, that this is just, or this is equitable. It's absolutely ludicrous that these guys are sitting over here. They worked out the land mass, our ancestral land, which they have given themselves. They've mapped it out where they're going to do all of this, and all we have to do, we've got to sit over here, and then we've got to be we just got to be accepting that someone else has designed our fate, and has designed our future, and the future of our children's children, and we must be sitting over here, and we must be cozy and kosher with something that is as demonic as this law called the TKLA, right? So colleagues, this is what we're talking about. This is the substance of our rejection and our total rejection of the traditional Khoi-San Leadership Act. And there's nobody that's going to come and tell us that we are going to sit here and we must just accept this piece of legislation, which is an absolute colonial piece of law, right? It's a colonial law. We are not going to accept that under no circumstances. We have not lost our mind. We are entirely awake. So that's the one part which needs your serious attention. These guys developed the act and gave themselves right and jurisdiction over land area in this country, right? So, but besides that, not only did they give themselves jurisdiction over land, what they gave them is equally concerning. Right? I'll get there now, but let me quickly maybe just get into what did they give the Khoi and the San people, right? We now know what they gave the Nguni and the Bantu people. What did they give? What are they giving the Khoi and the San people? Right? So now, after right, what you do is you go to the commission now, you present yourself, and then the commission is going to do some investigation. And you heard what the leaders said. They said in 3 months' time, they're going to come back and then they're going to adjudicate. They're going to tell you whether you were successful or not and so on. The question is not whether these guys are going to adjudicate whether you were successful or not in the next 3 months, the next 6 months, the next 12 months. The question is, what are they giving you leadership over? What is the extent of this leadership? Right? That's what we need to discuss. That's at stake here. Right? We know that the Bantu and Nguni have got, and we'll talk about the positions and the designations of their leadership. We'll talk about that just now. But what is important, very first for us to understand, is that these guys were given jurisdiction over land area. Land. Guys, do you understand land? Right? Let me tell you why it's important for you to understand land and the question of land. Because when you look at the Bafokeng tribe in the Northwest Province, the Bafokeng tribe was just a couple of years ago. The Bafokeng tribe was talking about 5 billion rand that they have in excess of 5 billion rand in terms of assets and liquidity, etc. They were talking about 5 billion rand. This year, a couple of years down the line, the Bafokeng is talking about over 50 billion rand, right? Over 50 billion rand. Those guys have the mining companies around there has given the Bafokeng people shares within the mines. That's important. That's the importance of what we're talking about here, colleagues. It's not just land for the sake of land, to have land that is just sitting there and just idle and the land is doing absolutely nothing. If you do not understand what we're talking about here and you are telling us just accept this TKLA and would accept this TKLA without having a discussion at the table, sitting down at the table with the state and talking about land, what are we talking about? What are we talking about? So the Bafokeng is sitting there boasting with over 50 billion rand. And if you go and you go study that area there, you will see how our people were in that much of the Khoi and the Bushman people there were on that land years before they came there. But they sitting with the mineral rights. They're sitting with the land rights and they're sitting with the mineral rights. And what are we sitting with? We're sitting with absolutely nothing. That's what is at stake here. It's much more than just playing the kind of games that these guys are playing with us and just wanting to talk about now finally the TKLA is going to recognize us. Recognize what? What are they recognizing? Right? This is absolute absurd. There's no way that we can be sitting around here and we can be cozy up to something that is absolutely ill-conceived. It's got no standing, right, whatsoever, right? So when we talk about land, we're talking about the productive sector of this country. When we're talking about land, we're talking about economy. When we're talking about land, we're talking about finances. When we're talking about land, we are talking about the continued existence of a people. You cannot exist without land, right? We cannot have our downline. We can't have our children's children, operating or enjoying anything if they don't have land. So when we talk about land, our children's children are in trouble, colleagues. That's what this is about. So these guys have secured the land and they've secured the land rights and they've secured it to themselves. We are left outside in the cold. So we have to look at that. So when we come to the Khoi and the San, what did they give us? if you read the law in section 5 on page 18, you'll quickly find when they talk about recognition of Khoi-San community and a branch. Now, what these guys have done is, these guys are not playing games, colleagues. These people were light years ahead of us. These people were thinking at a much higher level than what our leaders are thinking. I'm telling you, they were very, very, very meticulous when they designed the TKLA, right? What did they do? They designed the TKLA, and what did they give our leaders? They give us, yes, a community can go, and a community can go and apply for recognition, etc., etc., etc. But guess how this recognition is designed? That recognition is designed. A community must have either the community gets recognition or the community can apply for a branch, right? So that's what the community's got. The community's got can ask the community, say, no, we're a Nama community, we're a Bushman community, we're a Khoi community, we're Korana community, we're Griqua community. So you can go in there and then you can apply, right? And then the premier, after the commission, when the commission is now over and done, then you can go to the premier, and the premier will then decide, etc. Right. But again, guys, right? And Elmery is right there. Elmery was just talking about they even enriching themselves in the Northern Cape, right? Absolutely right. Let's just take the Northern Cape for let's indulge the legal mind, Elmery ties there. Let's take a dive into what she's putting on the table, right? We've been the majority in the Northern Cape for forever and a day, and the Northern Cape right now has got the biggest deposits of resources in this country. It's the biggest is in the Northern Cape, right? That's why everybody is rushing to the Northern Cape. You heard what Honorable Saintes was saying. Everybody is running to the Richtersveld. It's not just the Richtersveld that people are running to, right? People are running to the Richtersveld. People are running to the Makwaland. People are running all over the Northern Cape, because the Northern Cape, if you take a 25 square kilometer, in that for 25 square kilometer, you've got something like 30 resources in that land. That's what we're talking about. That's why there's this rush going in there, and obviously there's a lot more that we can talk about there. The Northern Cape is at the heart. Everybody wants to get in there. So the Richtersveld is just but one area. I can tell you now for a fact, you can go, besides Richtersveld, go right down over the entire Namakwa land. What's happening in Namakwa land? I'll tell you. I'll put it to you. What's happening in Namakwa land? Namakwa land, from the Kalahari side, from your Katu and your Olifantshoek, right down there, because remember that's already Katu is already part, and the Olifantshoek is already part of the Kalahari, right there, right up into, that's already part of the Kalahari. Right there, like you heard Elmery said, right there you've got iron ore, but not even iron ore is as important as the sister of iron ore. The sister of iron ore is called manganese. Because when you mine manganese, you mine iron ore. Iron ore, when you mine iron ore, you mine manganese. They're next to one another, because manganese is also a different source of iron. And for those who might not know, I've said it before, because I spend a lot of time in the area, and I spend a lot of time on what we call transition minerals or critical minerals, which is going to be is in a serious demand in the next 10, 20, 30, 50 years. Critical minerals. And in the Northern Cape, you take an area like your Postmasburg, Katu, Olifantshoek, Katu area, the Ben area. There we've got manganese. Manganese is critical for the transition mineral space. What is manganese used for? Manganese is used for lithium batteries. All the lithium batteries, EV cars, manganese, right? Battery storage, manganese. Solar panels, manganese. Turbines, wind turbines, manganese. Manganese, amongst other critical minerals, is in the Northern Cape. What else is there as part of the critical minerals? Lithium. There in the area on the other side there of Okip, in those areas there, they're mining lithium. They're also mining cobalt in the Makwa land, right? They're mining copper in Okip there. Whether you're talking about where Ronald and them are fighting in Priska, over there, there's copper. These are all the critical minerals which is needed right now. And our people do not understand what is at play. So when these guys have given themselves a jurisdiction over land, that's what we're talking about. We are talking about economics. If we do not understand that the Bantu and Nguni people gave themselves a jurisdiction over land area, and in the land is the deposits, the economic deposits, that's what these guys are after. And that's what we're missing from the conversation. So there's nobody that must come to us and come and talk to us as if we are we are asleep. We are not asleep. We are fully awake, and we are woke. We understand what is at play here, and therefore we need to challenge whatever it is that these guys are putting forward. Right? Let me tone down the conversation and bring it home now. So I've said to you, they want us to be leaders over a branch of people, like as in a political party. So you might be lucky if there's your leader over a community, right? But essentially, you are a leader over a branch, as in a political party. Now, let me tell you, there's very few spaces in the country where we can say that we're going to be leaders over a community. Places like Saron, places like Pella, we might we might get away with it. We might even get away in a place like Kokstad, there and so on. Places like the Richtersveld, spaces in the Namakwa land, you might get away with it, and you might say, okay, no, there our people are, and so you might have a community there, or that you might be a leader over. But to a large extent, our people are outside of those locations. We are in the cities. We're sitting here. I'm sitting in Johannesburg. You're sitting in Western Cape, etc. And the spaces where we are, we will be leaders over people. You'll be leaders over people, but there's no land. There's no land area. Colleagues, this is at the heart of this discussion that we're having. When we talk like this, it is not a simple no. These guys are now finally going to recognize us. Anthony, you are just in our way. You just don't know how desperately it's time for our people now to have a foot in the door. We must be, at least finally, we are recognized. Our people will, colleagues, there's no recognition here. There's absolutely no recognition. This is absolutely hogwash. Outside of the land, what recognition are we talking about? You cannot, you can't have that kind. You can't be this foolish. You can't be taking the children's wealth and accept not even crumbs. It was a different thing. If it was crumbs. If these people came to the table and said, "No, we'll give you some pieces of land, and we'll give you some land, we'll give you some rights in resources, rights and so on," we could have had a different discussion and say, "Okay, let's talk." Because we're talking land, we're talking economy, we're talking resources, rights. we could probably start the conversation. We are starting from nowhere, from absolutely nowhere, right? I need to conclude the session for tonight, right? When we talk about the different positions of recognition, this is what the Act is saying, right? The Act is recognizing the following. These are the following traditional leadership positions for the traditional people, right? These are the following positions. Number one, a king or a queen, right? King or queen. Number two, a principal traditional leader. That's what the Act is saying. Number three, a senior traditional leader, right? Number four, a headman or headwoman, right? Those are the four designations as far as leadership positions are concerned for the traditional leaders, which is the Khoi and the San. And this heading here underscores what I asked you earlier on, when I asked you, says, if chapter 12 of the Constitution also includes the Khoi and the San, why is there a distinction? Even here, they make a distinction between the Khoi and the San and the Bantu and Nguni. They made it. This is their law. They wrote it, right? So they've got the four positions for the Bantu and Nguni people. Now let's look at what are the positions of recognition for the Khoi and the San people. There are two. Number one, senior Khoi-San leader. And number two, a branch head. That's it. Nothing else. Now you talk to me and you tell me that in a public hearing, you will be able to sit there after we've already been in some public hearings and we already brought this to their attention. We already brought this to their attention in public hearings and they rejected it. They went stubbornly. They went to go and write this thing, and they came here and they presented us with this rubbish. And then people are telling us we must accept this and we must be. There's a senior Khoi-San leader and there's a branch head. That's it. And the Bantu and Nguni people get a king and a queen, a principal traditional leader, a senior traditional leader, a headman and a headwoman, for whatever that means. This is the level of marginalization, oppression, and suppression that these guys have been subjecting us to. And all they want us to do, and someone is coming on a live in a public space and saying to us that no, all we must do, we must go to a public consultation and we must go and challenge them in a public consultation. I mean, really, as if we have not done that before, right? So, colleagues, we must not play with one another. If you are not schooled in this space, I beg of you, any of the leaders out there, I beg of you, don't come in the public space and come and make pronouncements and speak on issues like this that you have you have not read. You have not read. You didn't read. You didn't give yourself the opportunity to go and read and spend the night here before you come into a public space and you're coming to tell us what it is that we must do. We must accept the TKLA without you having read through the TKLA yourself. No, colleagues, it can't be right. Now, I'm concluding with the following, and I'm going to quickly make a quick comparison between what you just heard now that comes from the TKLA. Now I'm going quickly because I'm just going to give you just two articles out of UNDRIP, just two, not more than two. I don't want to waste your time. Let's go to UNDRIP now. So now we saw what this government is giving us, or at least want to give us in the TKLA. Now let's compare that to what UNDRIP is saying, because this is why I know that people have not read UNDRIP. Now, what is UNDRIP? It's very important that people must understand UNDRIP and the importance of UNDRIP and why it is that we are giving our entire energy in UNDRIP. So I read some of what UNDRIP is saying the other day. I'm just going to continue, but I'll give you two articles within UNDRIP. Now, UNDRIP is the United Nations Declarations on the Rights of Indigenous People. This piece of this declaration is the basic framework which the South African government has agreed to at the United Nations. The basic framework, which means these are the basic conditions, the basic provisions which they have exceeded. Die is die basiese raamwerk wat die Suid-Afrikaanse regering alreeds ooreengestem het met die Verenigde Nasies. Hulle klaar. Hulle het dit saamgestem in 2007. Hulle het weer in 2014 het hulle weer teruggegaan, het hulle weer gaan saamstem en sê ja nee, is reg, ons gaan onsself onderwerp aan hierdie ding, ons gaan hierdie ding doen. En soos ek nou Sondag gesê het, en in 2016, toe kom hulle, toe sê hulle nee, ons gaan nou hierdie ding in werking instel, in 2016. 2007 het hulle dit goedgekeur, hulle het saamgestem, hulle het gevote in favor van UNDRIP, by die United Nations hoofkantoor in New York. 2014 het hulle onderneem dat ons gaan definitief, ons is committed tot hierdie UNDRIP, 46 artikels, ons gaan daarby volhou, reg? En dan die derde keer was toe hulle in 2016, luister hoor die datums, 2007, 2014 en 2016. In 2016 toe kwam hulle toe sê hulle nee, is reg, ons gaan nou hierdie wetgewing in werking instel. Dis wat hulle gesê het in 2016, reg? Nou kom ons kyk wat het hulle toe gedoen. Kom ons kyk wat sê hulle toe hulle saamgestem het op UNDRIP. Wat het hulle gesê? Dis wat die volgende wat hulle sê, en as jy UNDRIP gaan lees en jy kan gou daarso bladsy 8 gaan lees. As 32 bladsy. Ek gaan gou net die stukkie lees waar hulle sê die volgende is sê UNDRIP, encouraging states to comply with and effectively implement all their obligations as they apply to indigenous peoples under international instruments, in particular those related to human rights, in consultation and cooperation with the peoples concerned. So they've subjected themselves to international legal instruments, and they've equally subjected themselves to consultation, to human rights, to consultation, and to cooperation with the indigenous people. That's their undertaking. Then also what have they undertaken? Emphasizing that the United Nations has an important and continuing role to play in promoting and protecting the rights of indigenous people. So they have also exceeded, they have committed themselves to say that we agree that the United Nations have got an important role to play in promoting and protecting the rights of indigenous people. They cannot now come. Someone in parliament or someone in the cabinet and someone in government cannot come, or someone in the state cannot now come and say, no, we are going to give you a law which is far less than what they have agreed to. They have agreed to UNDRIP, and so they cannot come now and they're going to give us far less than what they have agreed to, right? So this is what they said before I get into the two articles. They say, solemnly proclaim the following United Nations Declaration on the Rights of Indigenous Peoples as a standard of achievement to be pursued in a spirit of partnership and mutual respect. Right. I read the Article 1 for you the other day. I want to read Article 2 tonight. Just Article 2 and Article 8. Article 2 says the following. Indigenous people and individuals are free and equal to all other peoples and individuals, and have the right to be free from any kind of discrimination in the exercise of their rights, in particular that based on their indigenous origin or identity. We've got a right to be free. We've got a right not to be discriminated against. We've got a right to our indigenous origin or regional identity. We've got that right. They have solemnly declared that we have that right, the South African government. But now what have they done? They've created a law. They've created a law that make us far less than the Bantu and Nguni people. The question is, why? Why would they do that? Why would they become so demonic in their approach? Let me conclude with Article 8. Article 8 says the following. There's two sections, Section 1 and Section 2. Section 1 says, indigenous people and individuals have the right not to be subject to forced assimilation or destruction of their culture. Forced assimilation. Kom ons praat van geforseerde assimilasie. Wat het die regering gedoen? En ons kan dit nie sien nie, en ons dink nou net nee, is 'n kwessie van nee, 'n mens moet nie diskrimineer nie, en 'n mens moet nie rassisties wees nie. Maar wat het die regering gemaak in die laaste 30 jaar? Hulle het seker gemaak dat die areas waar ons mense woon, dat hulle die area die skole in die area vol maak van die Bantu en die Nguni kinders, sodat daar dat ons geforseer word en geassimileer word. Ons word onderingeneem, en soveel so, ek het iemand gelees op Facebook wat gesê het, dat hierdie ding is so erg, dat omdat hy donker van kleur is hy so getraumatiseer, omdat hy nie die Bantu taal kan praat nie, hulle forceer jou basies, dat jy hulle taal moet praat. Hulle dan geonderneem, dat ons nie geforceer gaan word nie, dat ons kan wees wie ons is, ons eie identiteit, en dit is waarom UNDRIP die standaard is, en dit het niks te doen met ons, dat ons teen Bantu mense is, en teen Nguni mense is nie. Dit kan nie wees nie, collega's. Dit kan nie wees dat jy ons nou gaan sê, ja, julle is gekant teen die Bantu en die Nguni mense. Ons is nie gekant teen die Bantu en die Nguni mense is gekant teen ons. Hulle het wette geskryf wat ons uitsluit. Hulle het wette gesluit om ons te onderdruk. Hulle het wette geskryf om ons te assimileer in hulle in. Ons kan nie hierso sit en ons gaan hierdie wetgewing aanvaar net so nie. Nee, collega's. Ons moet opstaan, ons moet terugfight vir ons regte. Nommer 2, artikel 8, die tweede gedeelte van artikel 8 lees as volg. States shall provide effective mechanisms for prevention of and a redress for. Number 1. Die staat moet effectieve mechanisme in plek sit om te voorkom, die volgende te voorkom. Any action which has the aim or effect of depriving them of their integrity as distinct peoples, or of their cultural values or ethnic identity, the state must effect mechanism that prevent this, that redress this. Even so, not only must they prevent it, but they must also redress it, which means where it's taken place, there must be a mechanism that must address that. So that's the first thing. Wherever it is where our distinctiveness as a people are being deprived, the state must implement a mechanism that must prevent that and must redress. It's not taking place in South Africa. Nowhere. It's never taken place. And secondly, any action which has the aim or effect of dispossessing them of their lands, territories, or resources. What must the state do? The state must implement effective mechanisms to prevent us from losing our territories and our lands and resources. They must do so, and where it is lost, they must redress it. These guys have just decided they are not going to do it. They must redress our land and our territories and the resources. And then they wrote an act, the TKLA, that is in stark violation of their undertaking. And we must sit. We must be told that nobody is going to tell them that they are not, that they must do away with the TKLA. That's what we are told. We are told that there's nobody that's going to tell them. We are stating yet categorically tonight, there's nobody that's going to tell us as the indigenous people that we are not going to stand up for our rights. Right? This state has made undertakings in UNDRIP at the United Nations level. We are going to hold them accountable. We are not going to be sitting out here and make idle threats and say, no, we are going to the court and we're going to the Constitutional Court. You can bet your pretty life on it. We are preparing for the Constitutional Court because the state has undertaken that they will implement mechanisms that will protect us. And where we have lost the land, where we've lost our resources, where we've lost our territories, that they will redress it. And they have done absolutely nothing to do that. Nothing. Even where they have redressed land, let's speak about that. People said, no, but you're talking nonsense. There are people in the Northern Cape, they've received the land. Look at the Bushman people, they've received land in the Kalahari, in the Kalahari. You go and speak to the community in the Kalahari. Go speak to them. For more than 10 years, that land is under administration. More than 10 years. More than 10 years, that land is under administration. They can't do nothing with that land. There's no productiveness. That land in the Kalahari, which was supposedly given back to our people there, the Bushman people there, there's no benefit, no support whatsoever that they derive out of that land. For 10 years. I challenge you, 10 years, our people have not been having any benefit out of the land that was supposedly returned unto them. No, colleagues. No, this is a serious fight. There's nobody that's going to come here and come and tell us that we must just accept this TKLA. We are not going to accept it. We are going to fight back big time, seriously. We are not playing games here. Number 3. Under the third section, under the second part of Article 8. Any form of forced population transfer which has the aim or effect of violating or undermining any of their rights. The state must put a mechanism where our population are being forced, right? They must put a mechanism. They have not done that. Number 4. Any form of forced assimilation or integration. That's what they are doing consistently. They said, no, we must not be racist. We are just all the same. We are just all the same. Yet they have undertaken internationally that what they will do is they will put a mechanism in place, and preventative mechanism where there will be no forced assimilation. There will be no forced integration. Yet this state has become a law unto themselves. They have developed a law which is now making us even far less than the Bantu and Nguni people who are also settlers in this land. We are putting it on record that the Bantu and Nguni people are settlers on the indigenous people's land. This is our ancestral land. We can't be scared. Ons kan nie vir ewig bang wees om te sê nee, mense, kom ons wees net saam, kom ons werk net saam en dat ons net almal saam wees en gelukkig wees. Die mense het 'n law, 'n wet geskryf wat sê julle is minder as ons. Is 'n wet wat hulle geskryf het. Hulle het ons minder gemaak in 'n wet, in 'n wetgewing en die mense sê ons moet hierdie wetgewing aanvaar. Hierdie mense is dan ook settlers. Hulle is net soos die wit mense, soos die kolonialiste, as hulle nou die kolonialiste. Hulle het ook kom settle op ons ancestral land. En ons weet dat genoeg bewyse dat ons mense, ons praat van die Boesman en die Khoi mense, ons praat maklik van 100,000 jaar, né? Maar die ancestors van die Khoi en die San mense, ons praat van ten minste 3,3 miljoen jaar terug was ons mense hierso gewees. Ons kan nie, kollegas, as jy wil kwaad raak en jy voel nee, ons vat jou nou, ons kom jou te na en ons moenie so praat nie, kollegas, ons kan nie rassiste wees nie, ons sal nooit rassiste wees nie. Ons het familie onder hierdie mense, maar wat ons nie kan doen nie. Ons kan nie hierso nou meer sit en net hande klap en net gelukkig is met die scraps nie. En met die oorskietsels nie. In fact, as dit nog scraps en oorskietsels en krummels was, kon 'n mens nog meer gesels het. Ons kan nie meer so aangaan nie, kollegas. En het is jammer, hierdie live is vanaand nou 'n bietjie lank, maar julle kan sien hoe intens hierdie gesprek is, hoe diep dit is. Dis pynlik. Ons het alles verloor. En hierdie mense het hulle self reg gegee oor land en oor die resources. En hulle gee vir ons leierskap net oor ons mense. En ons mense is in armoede, ons mense is te neergedruk, ons mense word uitgeskryf uit elke wetgewing wat hierdie mense geskryf het, whether jy praat van employment equity, whether jy praat van affirmative action, whether jy praat van triple BEE, ons mense is uitgeskryf in elke wet uit. En die mense kan maar kwaad wees en sê, ons is hier teen Bantu en Nguni mense, ons sal nooit teen Bantu en Nguni mense is nie. Ons is teen die onreg wat Bantu en Nguni mense doen teenoor ons en teenoor ons kinders en ons nageslagte. Ons kan nie hierso sit en aanvaar dat iemand vir ons kom sê, en ons moet die TKLA net aanvaar, van hierdie is die wetgewing van ons werk, ons is nou in 'n demokrasie. Ons is in 'n demokrasie en daai demokrasie het ons uitgesluit. Die tyd het nou gekom dat jy moet opstaan, Khoi-kind. Die tyd het nou gekom dat jy moet opstaan, Boesman-kind. Die tyd het gekom dat jy moet opstaan, Korana-kind. Die tyd het aangebreek dat jy moet opstaan, Griekwa-kind. Die tyd het aangebreek dat jy moet opstaan, Nama-kind. Die tyd is nou. Ons kan nie nou meer Hanna en nou hier rondmors nie. Hierdie mense het wette geskryf wat julle uitsluit, wat julle eenkant los. En dis die waarheid, dis die realiteit wat ons het vir julle vanaand die wet gelees. Die wet wat sekere van ons mense sê, ons moet net onsself onderwerp aan hierdie wet. Ons het die wet gelees, ons spreek nie uit ons emosie uit nie. Ons praat die feite wat op die tafel is. En dan gee ons vir jou, wat het hierdie mense internasionaal ooreengekom. En hulle doen nie dit wat hulle internasionaal gesê het nie. Dis tyd Boesman-kind. Dis tyd Khoi-kind. Kom ons staan nou op. En kom ons vat ons krag terug. En kom ons doen dit saam. Die tyd is nou. En so, laastens, kom ons share hierdie video. Kom ons gaan uit en gaan share dit met ander mense. Wyd en syd. Die tyd het gekom. Nie net dit nie, kom ons nie net share hierdie video nie, maar kom ons maak ook seker dat dat ons onsself, waar ons self bevind in die land of in die buiteland, kom ons organiseer ons mense. Let's share the video. Let's organize our people. There's nothing worse than a people who are not organized. Let's organize our people. Let's organize our thinking. Let's organize our history. Let's organize our resources. Organize, organize, organize. First of all, a call to action. Let's share this video. Number 2, let's organize ourselves. Right? Number 3, let's invite more people to get on board and to get involved in this fight. And number 4, if you are in support of the work that IFNASA is doing, we've received a lot of emails. We are encouraging you, your organization, in your personal capacity, send us an email, ifnasa2016@gmail.com, ifnasa2016@gmail.com. Send us an email with your support. Go online and check there. You'll see Denny's contact number there. You get a contact number. You can get in. You can drop a WhatsApp message if you want to get involved. If you want to get in the inner circle, you want to get in a little bit more involved, a little bit higher. The time is now, colleagues. You cannot be sitting over here when these people have continue to make laws, continue to write laws which excludes us, marginalize us, oppress us. This is serious, colleagues. We are not playing. These guys are not playing with us. They want to get this law out because they want to get the supposed so-called recognition so that some people can say, no, these people are just mad. We have recognized them. We have recognized them. Listen, colleagues, this cannot be further from the truth. The time has come now. Die tyd het gekom, Boesman kind. Die tyd het gekom, Khoi kind. Die tyd het gekom dat jy opstaan en dat jy jou regmatige plek inneem. Whether jy in IFNASA kom en jy kom werk en jy help saamwerk, whether jy daar so op 'n hoekie is, jy kan nie meer daar een kant is nie. Iewers ons roep almal, alle organisasies, individuele, kom naby. Kom ons vat hierdie ene saam. Wanneer ons hof toe gaan, wat die dag wanneer ons hofstukke gaan indien, daai dag wil ons hê julle moet in julle numbers kom na die grondwet hof toe, wanneer ons die saak gaan aanhange maak in die grondwet hof, want dan gaan ons die media uitnooi, ons gaan almal uitnooi, ons gaan ons eerste dag is van ons grootste pushback campaign. Ons gaan nie net hierso kom sit en geraas maak en march nie en skree hier van die kant nie. Ons gaan nou hierdie ouens, ons gaan nou hierdie regering, ons gaan hulle gaan aanvat by die plek waar ons weet dit saak maak. En ons gaan vir hulle nou in die grondwet hof gaan aanvat. Collega's, baie dankie. Ek sien daar's oor die 200 boodskappe hierso. Baie dankie vir Show and Looks, vir julle Setup Holdings. Setup Holdings, asseblief man, gee vir ons 'n naam daar, Leer Witboy, baie dankie vir die mooi saamgesprek daar. Leer Martinez, Leer Tony Setchel, baie dankie. Die wet is aan ons kant, absoluut Leer Tony, ek stem saam met u. Kom ons beklei vir wat aan ons toekom, sê Leer Tony Martinez by sê veral ons jeug wat drugs en in alcohol verval, wat absoluut Leer Martinez. Ons leeg leer, dis wat hulle doen. Jy moet net gaan kyk hoe die ouens dit uitgewerk, Leer Martinez, collega's. Hulle het so gemaak dat ons die manne van die Khoi en San, dat hulle uit mekaar uitval. En hulle target ons jeug, ons jong manne. Hulle val uit mekaar uit, sodat wat doen hulle in die dinge se? Wat doen hulle? Hulle vat dan die Khoi en die San se vroumense en ons vroumense begin sê, die manne is te useless. Ek gaan maar rade vir my 'n man vat wat werk, 'n man wat kar het, 'n man wat inkomste het. Die mense het dit beplan. Die feit dat ons manne nie werk nie. Die feit dat ons manne dinge se magteloos lê en in die strate rond en soms in die oggende opstaan en die vrou vat na die bushalte toe of na die taxi toe. Sê vir jou 'n storie. Hierdie ding is uitgewerk, collega's. As jy nog dink hierdie mense het hier gekom om jokes te maak, dan moet jy baie vinnig wakker skrik, want dit is nie so nie. Baie dankie Mohammed Evans, die draadsitters met moet nou regkom. Ek stem saam daarso. Bruce say salute leadership, bit late, but we'll watch from the start. Absolutely, please, Walter Phillips. Amen, bro. Baie dankie vir die inkom. Educate our people. Baie dankie, Elmarie. Leer Witboy, 10 miljoen sterk. Absolutely, ons moet kom. Leer MJ Tate, the state Busman kind. He who has an ear, let him hear. Joseph, yes, with unity. Joseph asking, thank you very much, Pam. Exactly. The composition of where's Pam's the composition of the board is a conflict of interest because we are not adequately represented. Absolutely, Pam, you absolutely spot on. Thanks, Jeremy. Forward. So colleagues, thank you very much for indulging us this evening. Walter Phillips, we see you. You guys, thank you very much for your patience tonight. Let's go share. Let's get the show on the road. Leader Tony, we've the discussion between us is long overdue. Please let's make some time after this meeting, even tonight, if we can just quickly share some numbers, or so that we can get that conversation going as we're busy preparing ourselves, to finally knock on the door of the Constitutional Court. We are not going to be sitting and waiting here and be worried about whether we've got the money or not. We've got enough. We've got enough proof. We've got empirical evidence of what we're talking about. It's all over the place. We are the only people who think that we do not have enough. We've got more than enough to take these guys on. The time has come now. Trevor Smith, thank you for your Edward Weingart. Thank you very much for your patience tonight, colleagues. Let's go out there. Let's go make this. There's a number of others I might not have read it, colleagues. I know you are out there. We know that we have come together, and we are going to take the fight to these people. Just check and see what it is that we're doing. We're coming back on Sunday evening at 7 o'clock. We'll come with some there's some news. Mark Hendricks, thank you very much, my pastor, for your commitment coming out there. Chief Nick Fasagi there from the Katu area, who's providing us for years and years solid support. It's coming out of the Katu area there. We are now maybe as we conclude, Mark Hendricks, you're a pastor. We need people like you. We need the pastors, the intercessors. We need you guys to really at this time to pray with us, to pray for us, to take our hands, to keep us in prayer, because the fight that we are just entering now is no child's play, and we cannot undermine and underestimate the opposition to what it is that we're about to do. We must not be foolish to think that you are going to take on this. There is a hell of a lot of demonic activity that is at play in the shadows, and we dare not sleep on our laurels. We need you guys, the pastors. We need the intercessors. We need our men and women. I don't care. I don't know where or to what faith you subscribe to. The time has come now that we take hands and we push back like we've never pushed back before. So join the work that IFNASA is doing, colleagues. We've got some beautiful things that's on the cards. Maybe just lastly, we'll have the IFNASA leadership conference at the end of July. We are going to go in there. We're going to do a lot of structuring and restructuring. Talk to us about your involvement in IFNASA. Let's hear what it is that you have an offer. We are going to the Northern Cape. We're not going to say where right now, but we're going to the Northern Cape, where we're going to have a strategic conference and plan and organize. After that conference, will probably be much clearer in terms of when we are submitting to the Constitutional Court. When after the conference will come out, we'll make it public, and then we'll also share with you the direction that IFNASA is taking. It is not just IFNASA, colleagues. There's lots of other organizations. There's a number of chiefs who's coming forward, who's giving us their support. They are going to do so in writing. They're going to come in public, and they are going to give us their support. So whatever you do, if you know a chief, if you know leaders of the Khoi and the San, wherever you find yourself, bring them alongside the work that we are doing. The email again is ifnasa2016@gmail.com. We are extremely excited for what it is that we are busy achieving. I want to thank the IFNASA team. There are people behind. Some people think that because they see me, they think that's the sum total of the institution. I'm telling you, we have got people. Some are on here, some are not on here. We've got some very, very well-grounded, well-groomed leaders in IFNASA, which we are extremely excited. And very soon we're going to unveil the leaders of IFNASA who's doing sterling work behind the scene. I'm definitely not alone. Thank you, colleagues. Peace to you. And as the Khoi people would say, kei gangangs. Baie dankie vir vanaand. Vrede en tot Sondag aan 7 uur. Tot ziens.